Post a photo or something.
1, 2, 3, go.
Hello, everyone. So today we are going to hear from an expert, and we are going to talk about things relating to our topic today of living, dying, and leaving a legacy. So there are things that we can do to make sure that our wishes are carried out. So today I want to introduce you to Jim Ashmore, who is an attorney and I like to think a friend.
Yes.
That can help answer some of the questions and probably create more questions for you. So Jim, you would give us just a quick bio on yourself.
Sure. I have been practicing 32 years. I am Brett Nelson's partner at Nelson Law Group in Flower Mound. I do estate planning, probate, family law, and I also mediate.
So he does all the things over the years. So any of that, if it's a need, this may be someone you want to talk to.
Mm-hmm.
So some questions, we want to give people food for thought. So when people think about living, dying, and leaving a legacy, what would you say is the most important thing from a legal perspective that people should do?
Well, the most important thing is to have a plan, to come up with an estate plan. The last thing you want to do is put your family through a lot of things after you die. And the percentage of people who actually go and have an estate plan are less than you might think. And when you don't have an estate plan, you leave it all on your family. And there are ways that we'll talk about that you can even avoid probate. So
I think in the discussions that I've had with different people about this, it's one of the greatest gifts that you can give to your family or friends, whoever it is that's going to be taking care of for things for you.
Mm-hmm.
And so with estate planning, what would you say are the essential documents that should be done, and kind of what information would one need to gather in order to put all this together?
Well, you start with a will. There's a will. You need to have a durable power of attorney for people to conduct your business affairs. Medical power of attorney, a directive to physicians, and a HIPAA release. And those are when we talk about, we call it a will package at Nelson Law Group. Those are the things that we include in that will package. As far as information that needs to be gathered, having the addresses, for example, if you want someone to be your power of attorney, you need to get their address, have their address. Any other people like your medical power of attorney, you need to gather addresses of people, and take time with your attorney to go through, because we do send out a pretty extensive information packet to fill out before you come in. So I don't have to track people down to get addresses because they've already given them to me.
Right.
And at that consultation, I can, if there's missing information, I can tell them this is what I need. But addresses are really the most important.
Okay. And you mentioned durable power of attorney, and what I've run into in some different real estate, situations, it depends on how that power of attorney is written and
Yes.
what it allows you to do.
Yes,
So making sure that it's comprehensive
yes,
and includes, like in the case that I ran up against, the person that had the power of attorney did not have the power of attorney to sell the real estate.
mm-hmm.
They had everything else,
Yep,
but we were like, well, that's kind of a showstopper, y'all.
yes,
And it was. So making sure that who you're dealing with, that they cover all the bases of what you need covered, right?
yes. And the other thing that I know I'm an attorney, I get it, but the other thing I encourage people to do is not try to do their own.
Oh, yes.
Because let's say they didn't do this right. The person uh, isn't competent anymore, so they can't revoke it,
Right.
and they can't use it if it's not done. I've seen things like you're talking about, that there's powers of attorney, and they did them themselves. This just happened recently, and they didn't mark any powers. None.
Oh, no.
None.
Yeah.
So that's a problem, especially when you're trying to sell a house.
Well, right. And so, yeah, it's funny in real estate, the different things we run into and the different things we learn that, number one, we probably never cared to know. But that's why we also consult with professionals to find out a lot of these things. So what would you say are some of the common misconceptions that people have about estate planning, or what holds them back from doing it?
I have my theory. My theory is something I went through, that you don't want to contemplate your own death.
Right.
And that's what you're doing. Okay?
Exactly.
And so it's a scary thing. And I get it. But it's really necessary.
Right.
But that's the biggest thing I see is that, I mean, I'll draft wills for people and then never see them again. So
What changed?
they don't want to deal with it. And yeah.
Okay, and so that kind of leads into, you prepare a will for someone. How often should a person have that reviewed? Or how often should they revisit it in case something changed?
I think, I like people, I tell my clients, review all of your stuff at least once a year. Even beneficiary designations
Oh, yeah.
on accounts, okay?
Yeah.
Just review it once a year. If there's family changes, someone dies, the will that you had drafted doesn't provide for that, then yeah, you need to change it. And it's very simple. You can do what's called a codicil, and you don't have to do a whole new will.
Right.
But yes, life changes. You know, your power of attorney may decide they don't want to be your power of attorney. They may have told you that. So you gotta
Right.
get a new power of attorney.
Well,
The problem is people just put it off and then go do it. And a lot of times.
yes. So I know in my ex-in-law's situation, their will was 50 years old. It was as old as the youngest. Well, the executor had passed away 15 years ago, and the next in line was on the outs with the family. So here they were,
Yep.
and so harped on them to get their will redone. And they actually canceled their first appointment and didn't go to it, and we're like, okay. So then they finally did it a year before he passed. So, it's one of those things, you have to do it. It's part of adulting that we don't all like to think about. And so I think it's just that fear or having to face our own mortality
Yes.
that we don't want to think about. And my dad's 92, and he says, he goes, well, he said, everybody acts like they're not going to die. And I'm like, oh, we're talking about that today. Okay. My dad has everything planned to a T. So that's the better way. That's the gift to me and my brother.
Yes.
So all I got to do is check boxes.
Yes.
I've got a list to go by, but I also know if I deviate, I will be haunted to my dying day. So that's the other side of things.
That's right.
Yeah. So let's talk about assets that people have. What is a good option, or what ways do people need to think about protecting their assets as they get older from, lawsuits or from long-term care costs, things like that? What are different ways that people need to look at it, and what other professionals should they be consulting with?
So I'm going through this currently with my mother-in-law, who is 95 years old, trying to navigate the waters of the Medicare laws of Connecticut. And all the laws are
that's right, she's
different
not here.
in every different state. I don't do elder law. There are elder law attorneys that can help you set up trusts. They can help you transfer property while you're alive to people you want to transfer it to. But it has to be within 5 years of when you seek Medicaid. So there's a 5-year look back,
Right.
and that's another thing I try to tell people, and I know we're getting another professional involved. Financial planners can help with that too.
Right.
Some accountants who do that kind of work. So I usually refer people to them to set up these trusts. There's long-term care trusts. There's all kinds of ways to do it, but you just have to plan. You have to go start somewhere.
Right, and talking to someone, and a lot of times I find when I talk to someone, it just creates more questions
Yes,
that leads you down a different path to know that, oh wow, I need to go talk to this person too. And so
Yes.
you start to have your council or your board of directors or whatever you want to call it around you as you start to navigate these seasons of life.
yes,
Does that make sense?
yes, it does.
Okay.
I agree.
So then we like to think that our families, that our children, our siblings, or whoever, that everybody plays nice in the sandbox. Well, we know that in reality that doesn't always happen.
Yeah.
So what are some ways that you can make it so that doesn't happen, so that you're the one in control of how things go down or don't, and knowing that there could be conflicts, to make sure that kind of at the end of the day that brothers and sisters are still brothers and sisters?
Yes, well, you're right, that doesn't always happen that way. There are always will contests that, mom wasn't competent when she made her will. Well, mom probably was competent, but she probably cut somebody out of the will. So when you get the fractured family part of this, that's where the problems start. I try to encourage my clients to let their family know what the plan is.
Yeah.
Okay, and don't be shy about saying, okay, well, I'm leaving it to all of you, leaving everything to you all equally, in equal shares. Okay,
Right.
well, that's great as long as the family knows.
Right.
Okay, but then there are cases, and I drafted a will Monday, where one of the children is not in good standing with the
Okay.
parents. So
Yeah.
we left him $1.
Oh dear.
Okay, well, these people were very competent at the time they did this. So, and, I've been in a lot of family law wars in the courtroom. They are nothing like probate. It's a lot of people fighting over money that isn't theirs, that they believe they're entitled to.
There's that word.
Makes
Yeah.
sense?
Entitled.
Okay. So that's where a lot of the fractured families come from, and I'm seeing that too in guardianships now. Families are getting so fractured and fighting over things, and it's so getting the family involved would be a smart thing.
To start out with.
That's right.
To get everybody on the same page, whether
That's
they
right.
like the page they're on or not.
That's right.
Yeah.
That sometimes that might not be possible though. So
Well, I can think of scenarios where, yeah, that makes a lot of sense. So when you have an estate plan and you're drafting your will and all this stuff, who are the players that you need to think about to have on that team? Somebody says, oh, I have a will. Okay. Well, there's an executor. Okay. Who is that, and how do you choose them?
That's a really good question, because every case seems to be different. I mean, there's usually a pecking order in the family, okay? So if a couple does a will, then they usually leave everything to each other and designate the other as their executor. But then you have someone secondary, a successor executor. So it depends on how far down the line you want to go. So picking an executor, I think you make sure that whoever you pick is going to be sure to carry out your wishes. Okay?
Yeah.
Someone that you trust carry out your wishes.
True.
And that could be, I don't have any children, so my will names my wife as my executor. My backup executor is Brett. Okay? So you can name You can name attorneys, you can name accountants, you can name anybody you want to be your executor, as
Right.
long as they will qualify to be the executor.
Oh, okay, so what would qualify them to be one?
You mean unqualified?
Or unqualified?
Mhm.
Maybe that's, maybe that's the better way to look at it?
Serious criminal records, you owe the estate a bunch of money, the estate owes you a bunch of money. There's all kinds of different things that, or you've been convicted of a crime of moral turpitude, or you're under indictment.
Ah,
Yeah,
those kind, yeah, you wouldn't necessarily want them handling all of your stuff, so that makes sense.
right. And again,
Yeah.
going back to don't try to do your own will, please.
No, that, yeah, don't FISBO your will, is that kind of what you're saying?
There you
in
go.
the real estate world for sale by owner? Yeah, because
Yep.
we're professionals for a reason.
Mhm.
I'm sure you went to law school for a long time.
I did.
Yeah.
Long time ago, but I did.
And
Been
and
doing
you
this a
have
long time.
continuing education because things
Yep,
change.
Yep.
And so, yes, we have to stay on top of what there is, why it is, what's changed. Oh my gosh, what happened in the world last week that now affects what I'm doing today?
Mhm.
And people just don't think about it. They do, for example, a will or a power of attorney or whatever, and they park it over here, or a pay on death designation or a beneficiary of an insurance policy.
Mhm.
And you talk to a financial person, and the horror story is, okay, there was a spouse and they had a policy and they divorced and then remarried and then passed away, but they never changed the beneficiary, so guess who walks away with the money?
That's right.
And it happens every day.
And going back to something I alluded to before, it's possible to pre-plan everything so no one has to, your family doesn't even need to file for probate.
Oh, okay. So
Yeah.
tell us about that.
Designating beneficiaries on everything, checking it once a year, to make sure the beneficiaries are who you want. Okay, that's one step. Second step is, most of the time, if that's done, people are probating a house and a car. Okay, I don't mean to oversimplify, but it's a house and a car.
Right.
Okay, well, you can do, in Texas, we're one of the few states who allow transfer on death deeds or ladybird deeds.
Right.
Okay? So I try to encourage my clients to take advantage of that. You can always do a power of attorney to transfer title to a motor vehicle. So if you got accounts that you can designate beneficiaries, you got a house and a car,
Right.
everything's taken care of.
So then you don't have to probate or anything? at
You
that
wouldn't have to
point?
probate in that, no.
In that case?
And you can designate on your transfer on death deed, you can designate multiple beneficiaries, okay?
Oh,
Meaning-
okay, so an estate could be split,
That's right.
right, okay,
Uh-huh.
okay. What about, when you're saying transfer on death or beneficiaries, that's even on financial accounts, brokerage accounts, checking accounts?
Transfer
No?
on death deeds are
Or
only.
transfer, that's real estate,
Yeah, that's
Right.
only for real estate.
right, but,
And if you have, and you can do, well, mine, just using me as an example, my wife is the beneficiary of the house.
right,
Okay. If she's dead, then my niece is the beneficiary. So you can name other beneficiaries.
oh, okay,
Okay.
gotcha,
Yep.
that makes sense,
Mhm.
okay,
But the important thing, which a lot of lawyers don't tell people about these transfer on death deeds, okay, they're revocable. All right?
oh, okay.
Meaning you need to file them of record right when you do them, because they have no legal effect. If you go and file it after a person dies,
Oh,
doesn't
okay,
work. Doesn't work.
okay,
So see, there's a tip and trick that
there you go.
many people don't know about.
Well, and then you say they're revocable, so all of a sudden, whoever you have, say a house going to, they're on the outs now, and you're like, well, no, I'm not giving the house to them. You just have to file something
A revocation, yep.
to revoke that, but you always wanna make sure it's filed with the county in which you live or the county in which the property is?
County in which the property is.
Okay,
Yes.
and, or the state if it's different, because some people have second homes or vacation home or things, and you have to adhere to the laws of those states, right? Or no?
Yes.
Okay.
Yes, that's only effective for property, real property
In Texas?
in Texas.
That's true, okay.
But it has to be filed in the county where the property is. Because
Okay.
we've got, my wife and I have multiple properties.
Mm-hmm.
One here and one in Galveston. So I had to file the one in Galveston County and
Right.
Denton County, so.
Okay, that makes sense,
Mhm.
that makes sense. So we've touched on powers of attorney. So you said a durable power of attorney. What other kinds would someone need to think about having?
Sure. Well, a general power of attorney gives whoever you're giving your power to the ability to go and do any transact any business you could transact. It doesn't.
Okay,
It doesn't. That does not take effect upon your disability. Okay, your incapacity.
mm-hmm,
The durable power of attorney does not take effect until your incapacity, okay?
Okay.
So, I guess a better way to explain it is, in the durable power of attorney, when you say durable, it's because it survives your incapacity,
okay,
okay? So, a general power of attorney, depending on the language of it, is not a durable power of attorney. So if you are found to be incapacitated, incompetent, I think the forms I use say by 2 physicians,
mm-hmm,
then that's when that would take effect. But on a
Okay.
general power of attorney, if someone's found incompetent, then that's of no legal use anymore.
okay. And then you have a power of attorney and you have a will, so does the power of attorney end at some point?
Power of attorney ends upon a person's death.
Okay, so the power of attorney dies with the
That's
person
right.
at that, okay.
That's right.
And that's what I had understood all
That's
this
right.
time,
Yep.
so.
Yep.
And so we've talked about we've mentioned probate and, something in a trust or whatever, but so can you give kind of the Cliff Notes version of the probate process? Someone passes away and
Sure.
there's a house and a car and they didn't do the Lady Bird deed, they didn't do any of the things that they could have done.
Mhm.
What's the first thing a person should do and where does it go from there?
So you would file an application to probate the will in the county where the person lived. You can also file it where the person died. So you start it with an application. Once you file the application, you have to give posted notice and citation in the paper. Okay?
Okay.
So after that runs, you set a hearing and you go and you probate the will, have a hearing to probate the will, and for the court to issue what are called letters testamentary,
Right,
which allows your executor to carry out your wishes, to sell property. It's real important in a will to put that you want your executor to be independent,
right.
meaning not needing to go to court every time
They need to do
they
something.
They
Yeah.
need to do something. That's
Right.
the beauty of having a will. So once that's done, then it seems like everybody has their hand out. You have to post a notice to creditors. And then there's a couple of other paperwork items that the attorney does and files with the court. Once all that's done, then basically the case is over.
Okay.
Okay?
Yeah, I know when my mom passed, I didn't even go to court, but I had the letters testamentary and we were able to just go do
Mhm.
anything and everything we needed to do. So between, having that and the death certificate, that's pretty much everything you need.
Yeah.
Yeah, okay,
I agree.
okay. And then, so, I had a thought and it left. I hate when that happens. So,
Getting old.
I know,
me.
right? Those senior moments, there's a reason I
Yes.
deal a lot with seniors. I am one.
Mhm.
What was it? Oh, well. So out of all the things that we've talked about and things that you've dealt with and seen, what haven't we talked about that we should? When we're thinking about, I want to leave a legacy, I want to leave something to, say, my grandkids, I want to do whatever, how should I best do that and plan for those things?
Well, kind of like we've talked about, that the biggest thing is planning, right? And it's sometimes it's too late to plan, and so
Yep, right.
so a good opportunity after listening to me pratter on would be to get a lawyer and do your estate plan.
Well, that makes sense. And so we think about an estate plan and a will or whatever it is. We think of that in just thinking about seniors, older adults. But who should have one?
Oh, I think I think once you're a professional or you have a job, and maybe you have a kid, or two, or three, then it's you need to start young. But that's the main problem is young people don't want to think about their death.
Well,
And
right.
so that's the challenge that I've had, and I was guilty of it too, even as a lawyer. I didn't have my estate stuff, and I've been preaching to people all the time to get your estate plan together.
Yeah.
I didn't get it together until 2012 when I had a major surgery.
Oh, well.
So
An event created the
that's right.
urgency.
It did,
Yep.
and that happens a lot with people. I did a will for a former client for another matter because she was getting ready to have a surgery, and she's 28 years old, maybe. So I applauded her for doing that.
Oh, right. Well, and that's, my son's 30, and I'm like, okay, you don't have kids, you don't have a wife, you don't really have assets or anything, but you also, if you don't have the powers of attorney even, or the HIPAA releases anything, it doesn't matter that I'm mom.
No.
He's 30 years old, he's an adult. So you need to think about that, not in necessarily the context of age, but just pretty much that anybody and everybody
Yes.
should have that at that point. And I remembered what I was going to ask. So we've talked about a will and probate and a trust and whatever. What if somebody doesn't have a will?
Well,
Then who
that's
decides?
where it gets complicated.
Yeah.
So, in that event, you would have to file a heirship determination.
Yeah.
Okay. Well, that's where it really gets messy sometimes, because the court in all states there is something called intestate succession. Okay, so if someone dies without a will, that's how their estate passes according to what is in the Texas Estates Code.
Yeah.
Okay. Well, the complicating factor is that the court has to appoint an attorney to represent what are called the unknown heirs. Okay? Now, you might think that you don't have any siblings until something like that happens, and all of a sudden, attorneys can find siblings that you didn't know you had.
Half siblings and whatever.
And I, again, use my own life as an example. I went through that with my dad. He had 3 other kids. I didn't know that till after he died.
Oh my goodness.
Yeah. And that was really
Devastating, probably.
interesting. Yes.
Interesting, that's a good word.
That's right.
That's a good word.
That's right. So it's kind of the same procedure, except you have a lawyer involved, and then you have to find all the players. Maybe all the players are in the application.
Right.
So if they are, it's kind of the same ending.
Right.
Okay? Except in heirship proceedings, they can't be independent unless all the siblings agree or all of the heirs that are listed in the will. They can waive and have the administrator be independent. But typically, if that's not the case, then the administrator is dependent,
Court.
meaning that yes, you have to go to court, you have to post a bond,
Oh, wow.
a surety bond. Yeah, it just it's just a lot more work for your family.
It sounds like a mess, so I appreciate you sharing all this with
Sure.
us, Jim, because if you learn nothing else from today, plan.
Yes.
Create a plan and think of it this way. It's your life, or it's the end of your life, it's your things, it's your whatever that you're trying to decide, where does that go? How does that transfer? And like I said, you want to make sure at the end of the day, if it's possible, that brother and sister are still brother and sister and still talk, still love one another, whatever, and it doesn't create this whole family thing. And we probably see too many of those.
Yes.
I even see it in real estate transactions. It's like, oh my gosh, could everybody just play nice in the sandbox? It would be great.
No, it would be, wouldn't it?
Yeah, so anyway, if you have any questions, you can reach out to me. You can reach out to Jim at Nelson Law. And the word of the day is plan. So thank y'all for your time and attention.
Thank you.